I would like to welcome all the students, faculty, trustees, and staff to this just gorgeous facility for what promises to be a very, very special conversation and a special afternoon. President Upham and Chairman Wilson, thank you so much, not only for your support of today's visit, but also for your unswerving support of the College of Law throughout my deanship. Thank you to the team that has been working since May to make sure that today's visit runs so smoothly and is infused with TU charm. The list of those involved is way too long for a short introduction, but you know who you are, and please know that it is just my sincere privilege to work with you. And of course, thank you to today's esteemed guest, Justice Sonia Sotomayor, for taking time from her crowded schedule to visit with us today. It is truly the most meaningful and memorable honor of my career to welcome you to our University of Tulsa community. As the Dean of the University of Tulsa College Law, I am engaged by one question more than any other, namely, what does it mean to be a University of Tulsa or a TU lawyer? In preparing for today, in learning about Justice Sotomayor's life, her career trajectory, and her personality, I have finally found the perfect answer to this question. A TU lawyer practices law and lives life committed to the values that Justice Sotomayor embodies. So what does it mean to be a TU lawyer? It means working toward goals with tenacity and grace and humility, making excellence the standard, and seizing every experience, even those moments when we fall down, for learning and growth. Justice Sotomayor's path has been meteoric, rising from the projects in the South Bronx and Co-op City, to Princeton, where she won the Pine Prize, which is the highest award bestowed upon an undergraduate, to Yale Law School, to becoming a prosecutor of drug and child pornography rings, to a partnership in one of New York's premier boutique firms, to an appointment as one of the youngest nominees to the federal bench, and finally to her confirmation as the third woman and the first Latina Associate Justice on the U.S. Supreme Court. Now that career climb has doubtless been as grueling as it is impressive, and we claim that same determination as our professional standard. But while Justice Sotomayor's career appears meteoric, what I find so very real and so very inspiring is that it was not without serious challenges and setbacks. Justice Sotomayor was diagnosed with type 1 diabetes before she turned 8. She lost her father and her first cousin to the disease of addiction. She nearly failed a required psychology lab at Princeton because of a paralyzing fear of rats. And she struggled with some of her closest relationships. As a legal educator who encourages students to spend summers clerking at law firms, Justice Sotomayor's recounting of her struggles and insecurities as a summer associate resonated strongly with me. When a summer appointment at the prestigious Paul Weiss law firm failed to yield a customary offer of a full-time associate position, our honored guest embraced the moment as an opportunity for honest reflection. Through attentiveness to that internal compass that points toward one's passions, Justice Sotomayor changed course, swimming against the strong tide of expectation that led most Yale Law School students to white shoe law firms. Instead, she took a path less traveled to the Manhattan DA's office, and it is precisely this turn that steered Justice Sotomayor toward her current destination. And so for our students here today, be self-aware and be reflective in forging your own path. And embrace intermittent failure as a learning opportunity rather than a paralyzing roadblock. So I return to that question again. What does it mean to be a TU lawyer? A TU lawyer remains grounded as a foundation for compassion and giving back to those less fortunate. Justice Sotomayor's childhood, her family's experience with poverty, and her strong identification with her Puerto Rican roots converged as a potent force drawing her toward public service. As a public servant, she was undoubtedly a tough, hard-nosed prosecutor who more than once placed herself in harm's way to gather evidence and build a strong case. Yet, unlike some prosecutors, she did not always go for the jugular, but she often stepped metaphorically into the shoes of the defendant and the defendant's family, exercising compassion when warranted. It speaks volumes that Justice Sotomayor chose to launch her 3-day Oklahoma visit by spending time this morning with Booker T. Washington High School students. And it was just a tremendous experience to witness her interacting with the students. And she will also begin her day tomorrow with leaders from Oklahoma's Native American tribes. So for all you students here today, remember where you came from. Remember that you arrived at TU on the shoulders of others, and remember to give back so that others have similar opportunities. And finally, what does it mean to be a TU lawyer? A TU lawyer, day in and day out, nurtures relationships among friends, family, and colleagues. A TU lawyer builds an impeccable reputation for loyalty, decency, and integrity as a way to meld these relationships into supportive networks. I just loved reading the stories and vignettes in Justice Sotomayor's book about her family and friendships, from Abuelita to her colleagues at Pavia and Harcourt, from clients to fellow board members on civic boards. Now, of course, we develop these relationships because they enrich our lives on so many levels, and it allows us to do the same for others. But it's also worth noting that these relationships provided a wellspring of support when Justice Sotomayor was nominated for the federal bench, not once and not twice, but 3 times. Justice Sotomayor has lived so true to the words she wrote at age 21 in her Princeton senior yearbook. She writes, "The sum total of my life here has been made up of little parts from all of you. The sum total of my life here has been made up of little parts from all of you." Justice Sotomayor appreciates that we are all a complex mosaic defined by our interactions and indeed by our duties to each other as professionals, fellow citizens, and human beings. One of our colleagues at TU Law, Chapman Professor Bob Spoo, was fortunate enough to enter into Justice Sotomayor's orbit as a law clerk in 2001. As one of Bob's colleagues, I can assure you, Justice Sotomayor, that you have shaped his view of law and life, and I am grateful that our students are the lucky beneficiaries through his teaching and scholarship. Now, I even hear that he learned from Justice Sotomayor many of his dance moves that he demonstrates each year at our public interest law show. And I'm also grateful for that contribution, for it has provided many of us hours of entertainment and some laughter. Anyone, in all seriousness, anyone who knows Bob Spoo, who knows his keen intellect, his poetic use of language, and his disarming wit, also knows that he is truly one of those little parts that has undoubtedly enriched the sum total of your life, Justice Sotomayor, just as he enriches the sum total of so many of our lives. So it is now my great pleasure to turn this program over to the Honorable Sonia Sotomayor and Chapman Professor Robert Spoo. Thank you.
hate sitting still, and I hate being so far from you. But because of acoustical limitations, I can't get much closer to you, and I can't walk around. So I will walk around and start walking around halfway through. But if the people upstairs and in the back can't hear me when I do that, I'll have to come back here, okay? So that's the plan. I'll sit up here for half the show so everybody can hear it, and the other half we'll see if I can come down and say hello to you. The only thing about that is, you see all the people standing up with suits and little things in their ears? They're marshals, and their job is to protect me. And to do that, they're watching people, and they get a little excited when people jump up to embrace me or to touch me. And so please don't excite them, because as nice as they look, they can sometimes act very fast, okay? So anyway, Dean, Janet, that introduction was so very, very touching. I know how hard you've worked to put together this day, and it has had many, many components. And I'm grateful to TU, to the law school, to you, Dean, for all your efforts, and to my friend, Bob Spoo. And yes, he has immeasurably improved my life, starting from his note at Yale Law Journal, which I read and knew I was going to hire him. So for those law students who want to get brownie points, go find it and read it. Go ahead. Sorry to start, Bob.
Thank you, Justice. Am I audible? Is it working? Good. Well, I want to add my thanks to Dean Levitt for that gracious tribute to the Justice, and thank the Dean also for that somewhat exaggerated and maybe even surreal portrait of my so-called dancing. My wife Marjorie, who is in the audience, would certainly call it so-called dancing. Justice Sotomayor, let me add my brief welcome to Dean Levitt. It's both an institutional honor for all of us, and for me a deeply personal pleasure to be able to welcome you to our state, to our city, and our educational community today. It's been a keenly anticipated event for all of us. I last saw you in person 2 falls ago at the wonderful clerkship reunion that you hosted at the Supreme Court building in Washington, D.C. It's a gratifying pleasure to have another reunion with you here in Tulsa.
Dean Levitt, we got to get more Yaleys on your faculty.
And I just point out to our audience that a fact that some may not be aware of, and that is that in addition or among her duties as Associate Justice of the Supreme Court, the Justice is the 10th Circuit Justice and responsible for the 10th Circuit. And Oklahoma is one of the states that fall within the 10th Circuit. So we feel special pride in having that additional connection with you. Finally, before we begin, you've written of the touching words that a crime victim and a prosecution witness, a witness of yours, once spoke to you when you were a district attorney for New York County, assistant district attorney for New York County. Her gratitude found expression when she said to you, and I quote, "There's something very special about you. You've been blessed. I'm glad we met." Though the circumstances today are quite different from those, I couldn't put it better. Now to our chat. Let me begin by asking you a question that I think may resonate with a lot of, at least some of the slightly older folks in the crowd. And that is that as a child, you have...
I've reached that exalted age now.
Yeah, we have, yeah. You were engrossed by the flair and ingenuity of a TV defense attorney named Perry Mason. But you were all, and you've written about this, but you were also very fond of his regular opponent, the prosecutor Hamilton Berger. Most viewers probably rooted for one or the other. But you, have written that you admired both. Could you talk about that?
It's interesting, and you're right. Most people did admire one or the other, and often not Hamilton Berger, because he was always on the losing side against Perry Mason. In fact, during my hearing, I was asked what episode was it in which Perry had lost the case. And I didn't remember the name of the episode, and so you know a little background. I am told that Stennis staffers were going crazy in the background after the question was asked to find the show. And the senators were emailing one another, texting one another about the answers that were coming up. So you can tell how interested they were in my answers, right? They found some entertainment for a good half hour, by the way. For the younger people in this room, of which there are many, gratefully, Perry Mason was the first TV lawyer that had a weekly show. The show had a standard format, not the kind of show today where every week there's a different drama. In Perry Mason, the first half of the show, he investigated the crime with which his client was charged. In the second half of the show, it was a courtroom scene, and he questioned witnesses or cross-examined them generally. And somewhere near the end of the show, or at the very end of the show, he would break down a witness who would admit that he or she had committed the crime. Now, for the young lawyers in this room or the law students, I've had a 35-year career in law, 22 of them as a judge. That's never happened. To me, anyone I know, in any transcripts I've read, it was a pure TV fiction, okay? Nevertheless, I enjoyed the show with countless other people. I can't tell you how many, since I divulged how he inspired me. How many people have told me they were inspired to be judges because of Perry Mason. But in one episode, at the end of the show, Perry Mason and his Stella Street, his secretary, and his investigator were having dinner. And Berger was having dinner at another table, and they happened to leave together. And Perry went over to Berger and said, you know, it must be very frustrating to put that much work into a case and lose it. And Hamilton Berger looked up and said, no, my job as a prosecutor is to do justice. And if justice means that an innocent person has been acquitted, then I've done my job. And those words resonated with me. Those words, more than just about any other words on that show, stayed with me my entire life. And unlike my friends who thought that justice meant defending people who were accused of crimes, I understood that both sides were attempting to do justice. A prosecutor, by prosecuting people who were guilty, and when they were guilty, getting the conviction. But when they weren't, both sides probing and trying to come to the right answer. And yes, that meant an acquittal on occasion. I think any prosecutor who tells you that they never lost a case is a prosecutor who never took chances, and a prosecutor who never accepts that there's imperfection in life. And so I'm always suspect of those people. But putting that aside, that image of being a prosecutor as doing only justice stayed with me. And I hope that that's what I aspired to do when I was a prosecutor.
Well, let me ask a follow-up question that might relate to that, and that is that you've written, I think very eloquently, that the adversarial litigation process has, or at least should have, the larger purpose of, as you have put it, realizing the rule of law. how can we teach our students, our law students, many of whom are here in this room, how can we teach them to be both fierce legal combatants, but also to keep this higher goal in mind?
Respect. You have to go into, to be a good lawyer, you have to go into the process respecting your adversary. Even when they do something that you don't like, you have to understand the why of that. Sometimes it's simple despair. They've got a losing case and they lash out with anything they can. Sometimes you accept they're just not nice people. And those are realities that are true of every human interaction, and to deny they exist is to be naive. But in the main, they are like you. They have a client that they're trying to represent to the best of their ability. They're putting forth the best arguments that they can devise. They are trying to do right by the legal system. And if you accept that as what motivates most lawyers, and you respect your adversary enough to put yourself into their shoes, to anticipate what they're thinking about, what they're worried about, you'll be a great lawyer. You can't negotiate a case until you know what the other side needs and why. You really can't convince someone to come to the table and actually give something up, or you give something up, unless you understand their strength and their weaknesses. And so I think to be an ethical lawyer means to have respect for the process and for your adversaries, and for you to set your own standard of behavior. And that means no matter how low your adversary may come to do things, don't stoop to their level. Rise higher. Always practice with a sense that this is a noble profession. It's what I feel about the law. It's what I feel about being a justice. So much passion for the great things the law has done for people. If you can't practice with that same passion, use your law degree and go do something else, okay? But if it moves your belly, then stay in it and live it. Live your work with that passion. It really counts for something important.
Another kind of noble adversarialness is that can exist among the judges of a multi-judge court, such as you currently sit on. And one of your personal mantras we've learned through your writing is to build bridges instead of walls. How has this ideal been serving you so far on your current assignment at the Supreme Court?
As you know from my book, when I was a prosecutor, I made friends with defense attorneys, and one of my closest friends was someone who tried her first case against me and my second case against her. On the district court, you are a king or queen of your own courtroom. You don't have to search out the opinion of someone else and get them to agree with you. And so it's a different kind of judging because you're really working by yourself. On a court of appeals, it's much easier to talk to 2 judges than to talk to 8 others. You really have A, more time, and B, it is somewhat easier on the Court of Appeals to reach compromise because you can decide cases on narrower grounds and not affect the working of the system as much. There is more opportunity to build bridges on the Court of Appeals. Dissents, even on the Court of Appeal, were very, very rare. As you know, that's not been the case on the Supreme Court. For those in the audience who don't know it, regrettably, I've penned a number of dissents. But not by choice. But what I have found on this court, which is very, very different than the courts below, because on the courts below, you know that if you've gotten it wrong or the court has gotten a legal issue wrong, there's a court above, the Supreme Court, to fix it or to make a worse error, whichever way it goes. But the point is, there's a safety valve, and you respect that safety valve. When you're on the Supreme Court, the questions are generally monumental. And the principles go to the core of constitutional or statutory interpretation. It's a little bit harder to build bridges when you're talking to 8 other people, each of whom is as passionate as you are about the work they're doing. Each of you, and that's how we can stay friendly with each other, and that's the point I'm coming to. Despite the passion we reflect in our opinions, and you know that our opinions can sometimes be sharp, too often. Don't follow our example, by the way. The Court of Appeals judges usually get it better, okay? But our passions spill out on the Supreme Court because the issues are so critical to the nation. But despite that, we respect each other's passion. And because of that, we remain friendly with each other. And we build our own bridges in different ways. I think you may know that Justice Scalia and Justice Kagan now go hunting together. Now, I don't think I would do that because I don't like getting up early in the morning and getting wet and cold. So that's not my way of doing it. But we build personal relationships. We talk a lot about our disagreements. And we try to understand each other's view. And then you come to a point where you just have to cast your vote, and you can't build the bridges in the same way. Compromise on really critical issues can sometimes be very hard. But you should not forget that we are nearly unanimous in 60% of our cases, and a lot more, closer to 20 to 25%, we're 6-3 or 7-2. So it's not as if we can't build bridges. It's just that when it comes to that 15% of very difficult issues, we may likely remain divided.
Coming back to that rare 15%, of course, which receives so much public attention, despite the fact of unanimity or majority agreement in many cases. Dissents. I do have a question regarding that. You are an architect of bridges, and yet there are occasions in which you have found it necessary and compelling to make a public statement of your disagreement with your colleagues over a point. I don't have, of course, I'm not asking you about any particular case, past or pending, but if I may, could I ask what general considerations lead you to choose to file a dissent from a majority decision, or, of course, that much more rare animal, from a denial of certiorari?
Well, let's talk, there are two processes. It is very rare in a denial for certiorari that a judge issues a dissent. I think one consideration, this is oaky allergies, okay? It just started this morning and it hasn't abated yet.
And may I just say, I have a standing bless you, so I won't have to say it all.
Exactly, don't bother. This is going to continue for a while, sorry. For some justices, and even for me occasionally, you write a dissent from a grant of certiorari because the legal issue that was presented is critically important and it needs to be resolved. And you fear that the denial will send a signal of some sort that the court is agreeing with the court below. And that could be a very dangerous signal to practitioners below who may feel that they should give up because the court had what they perceived as a great vehicle, and we saw something that stopped it from being a great vehicle. So if you read some of my dissents and that of some of my other colleagues in granting certiorari, by the way, there are some non-lawyers in this room, so I should explain what that is. A petition for certiorari is a request by a losing party below for the court to reverse the judgment below. They lost, they want the Supreme Court to step in and tell the court below, you got it wrong. We get about 8,500 petitions of certiorari a year. We review every single one of them, and we vote yay or nay on every one of them. We grant only about 70 to 75 cases a year right now. In some years, we've granted many more. In other years, never less than that, never less than about 70, I don't think. But around 70 to 75 a year. So what's the reason we don't grant many? Because there are vehicle problems. An issue wasn't argued appropriately before. The party's not really getting at what the important issue is in the legal question. Lots of reasons why we say, no, we're not going to take the case. But sometimes the question is so important and so fundamental that you write to draw the attention to the bar. And all of us do that occasionally. Other times, you are saying something to the courts below who are getting things wrong, but the issue is going to evade review because it often will be sidestepped by other questions. And so you'll write a dissent from certiorari, basically saying, you know, court below, you're getting the standard of review wrong. You got the right result in this case, but please don't continue doing that because eventually you're going to make error. And some of my dissents do that. And sometimes the legal issue, and I wrote one a couple of terms ago, where you think the court has gotten something fundamentally wrong. And you're inviting the court to rethink its jurisprudence in light of jurisprudence that came after the earlier decision. And I did that on a question involving Alabama's death penalty procedures, which permit a judge to override a jury's verdict on whether to impose death or not. And so I wrote because I thought the court had gotten it wrong. Now, I only got one judge to join me on one piece of it, but my hope was that my conversation in that dissent would start some of my colleagues thinking. And that maybe over time, with more evidence of the things I was talking about in that dissent, others would change their mind and join me. So there are many, many reasons, but those are the most common.
Interesting. It's a kind of a sending up of a signal flare.
Absolutely. Diverse audiences, sometimes judges, sometimes practitioners, and sometimes your colleagues.
Well, I can't...
And I didn't answer your other question. I'm sorry, Bob, I forgot it. The other half of the question, which was, why do you dissent? And sometimes you don't. You'll be at conference, often in statutory cases, but occasionally on constitutional cases. And you're taking the vote around the room, and one or two judges say, I think the other way. But if you write it in this narrow way, I'll pocket my dissent. Pocket my dissent in our colloquial language is, I won't write one, and I'll join you. It is a tactical approach, getting the majority to narrow what they're doing and avoid greater problems that you think might exist with a wider ruling. But sometimes, and it's more common in statutory cases, the majority will agree to flag something that you think is important. And they will flag it for Congress so that if Congress disagrees, they can step in and you won't write the dissent. But generally, you write a dissent on constitutional questions because of the reasons I gave earlier. It's hard to compromise principles of disagreement in constitutional areas. They're fundamental to the functioning of law in society. And if you disagree with the majority's approach or with the majority's outcome, you're almost compelled to write. But on statutory questions, again, it's a question of signaling. Do you signal Congress that there's something they should think about or fix? And the most famous example of that was the Betsy, why am I blanking, Ledbetter case. It had to do with continuing violations in employment law. Someone's denied equal pay over a period of time, and the court said they were only entitled to the withheld wages for 3 years. Congress stepped in and made it a continuing violation and basically lifted what the court did. And everyone attributes what Congress did to the powerful dissent of Ruth Bader Ginsburg. And it was a very, very powerful dissent. And sometimes a dissent, and I've done it, for example, in an environmental case, it's a signal to the agency of, this is another way of looking at this, and perhaps you should think about this in your rulemaking. So again, dissents are important to send signals, but sometimes, and often, especially in the constitutional area, to explain generally why a different approach is required. And you hope over time that a dissent will become the majority.
Thank you. A very brief question, since you mentioned it, about judicial hobbies. Actually, this is a question submitted by one of our law students.
Judicial hobbies, okay.
Judicial hobbies. And this student noted the Justice Kagan, Justice Scalia hunting outing in Wyoming. And the question was, and it's actually, and as a lawyer I shouldn't ask a compound question, but
you'll always, that's okay.
What hobby or pastime of another justice would you like to share, or at least participate in? And is there a pastime you enjoy that you would like to share with another justice?
My colleagues are all enamored of opera. For reasons that I don't know, I really don't. When I was nominated, it was reported that I loved opera. I don't hate it, but it's not my favorite form of cultural entertainment. Mine is dance. I love the American Ballet Theater, and I love classical ballet. Not many of them like it at all. Some of them complain bitterly. But I have tried on occasion to invite some, and I'm going to keep trying because I love dance. But I don't like just classical dance. I go to modern dances. When I was in New York, Bob, I think even back then I was at ABT, and I used to go to Alvin Ailey and to some Martha Stewart, to a lot of the different venues. And so that pastime I love. The one that he and I have not been able to coordinate our schedules that I'd like to do more of is both Justice Alito and I are big jazz fans. And it turns out that quite often I turn up at a jazz venue and they tell me he's either been there a night or two before or he's coming a night or two after me. We just haven't been able to share that pastime together. We do share baseball games together. Justice Ginsburg, not with Justice Ginsburg. I don't, actually, her husband tried to get her to go to Cooperstown. The entire time that she's traveled up there every summer to see the Cooperstown Opera. But she never went until very recently. And she got enamored of Cooperstown because they had a section on women. And so they knew what they were doing when they invited her. But I don't think she's ever been to a baseball game. And I don't think I'll ever get her there. But occasionally, my colleagues and I will take our chambers together and go to a baseball game. So I hope that answered the question.
We're here in Indian country, and it's been reported that you view Native American law as an important part of the legal landscape. And you've spent some time in Indian country, and even with Native students. Could you discuss how your interest in Native American law developed?
That's actually an interesting question. I think not in Native American law, because when I visited the Pueblos, and I did that in New Mexico my second year on the bench, I think, it wasn't to study Native American law, it was just to interact with Native Americans. I had one Native American friend in law school, and because he's lived mostly in California, he's now in Washington State, but during most of our legal career, he was out in California. I really didn't get to travel to tribes with him. And we talked about Native American law on occasion, but not in depth. When I became a justice, he came to me to visit me one day, and he said, Sonia, I raised this with you just to have you think about it. The last time a justice met with any of the tribes or pueblos was about 13 or 14 years ago, when Justice Breyer and Justice O'Connor went, I think, was it Oklahoma? I don't remember where they visited, but they visited the tribal courts. They didn't actually meet with tribe members. And he said the tribes don't feel like they're a part of the court. And yet the court does affect tribal law in so many ways. I think it would be nice if they had a justice who took an interest in them as people. And so my first trip was to New Mexico, because that friend and a professor who taught Indian law out of Pace Law School in New York suggested that they were the oldest Indian tribes in America, and that out of respect, I should visit them first. And so that's what I did. And I didn't study tribal law. I I met with the people. I met with them and learned about how the tribes operated, how they ruled themselves internally. I learned a little bit about their law in the sense of how they mediated many of their disputes. I learned that for many tribes and pueblos, they're a matriarchal society, which you would have never thought of because in their more formalized leadership, it's all men. Their governors and chiefs are all men, and yet the women make the most important decisions for the tribe. And I guess that's true of many families, but I didn't realize that of Indians, okay? I think that when you learn about people, it gives you more of an antenna to pay attention to what you're doing a little bit more closely. And as tribal issues became more prevalent in my court, or as they began, not more prevalent, but as they began to arise, I did a lot of reading and a lot of studying and I went back to many of the seminal Indian cases that came up in the beginning of the country. And I started to study them carefully because I thought if I'm going to be asked to make decisions in an area of law that I virtually know nothing about, I better become a good student. And so that is really what stimulated my interest in tribal law. And as you know, I've written some majority opinions and I've written some dissents in that area too. And if you read my dissents, you're likely to see that I think the court sometimes goes away from the record a little too much. I mean, the precedential record a little too much.
Speaking of matriarchal centers of gravity, you've written very eloquently of an individual that Dean Levitt mentioned in her introduction, and that is your grandmother, Abuelita. And you've written of her fascination with poetry, with magic, with the spirit world. And you've noted that early on she felt that you had the gift of those dimensions, and that your mother intervened and didn't want you to go that way. What lasting effects do you feel that your Abuelita's magical world has had on you?
I'm not a voodoo believer. Great deal of respect for other people's religious beliefs. Although my grandmother's belief in spirits was contrary to her Catholic background, but she really didn't see a dichotomy between the two. She didn't think there was a contradiction, although many people reading my book have thought so. She saw that they coexisted, because in her world, there were good spirits and there were bad spirits. And depending on yourself and what you believed in, you called upon good spirits or bad ones, and you committed sins or didn't. But her belief, and even though I didn't share it and don't share it, I have respect for it. Just as I have respect for other religions that have different value systems and belief systems about their God and what that God requires or doesn't. Doesn't mean that, for example, I'm going to believe that things that might cause violence or harm to others are good things. But it does mean a fundamental respect that religion motivates people in different ways. And if you can accept that, you can be accepting of people who are different than you. Because the reality is that for many people of different colors, of different languages, and of different backgrounds, their religion is expressed in different ways. So if you can start by accepting their religious expressions, you can start better to accept them as human beings fundamentally no different than you. As I think I said in my book, I may not believe in it, but I don't spend a whole lot of time debunking it either. I just let it exist, okay?
And I should say, if it even needs any saying to anyone here, if you have not gone out and bought...
This is a good friend.
The justice did not put me up to this, but if you haven't gone out and bought that book, My Beloved World, you really should right away. It's a wonderful book. I've been dipping into it for some time, and I sat down and read it cover to cover. And it is not only substantively a wonderful book, it is not only a wonderful American story, but it is just beautifully written.
Thank you.
It really, really is.
It gave me a chance to have a non-legal voice. You know, I've always been a storyteller. And you know that from my speeches, and you heard some of them when you were with me. And people have always told me, write your legal opinions the way you write. You tell your stories. And I'm just not quite capable of that. But this book gave me license to let go of the lawyer in me and to just storytell. The greatest compliment I received about the book was from my own mother, who, when she read it, she called me up and said, "It sounds like you're sitting next to me, retelling the story." And so I knew I had captured my voice in the book.
Well, one of the important strands in that book, and one of the important woven strands of your own life tapestry, is the issue of affirmative action, which you've discussed very, very interestingly and I think boldly and forthrightly in the book. along with your many major academic achievements, also sometimes came an articulated skepticism about affirmative action from various quarters. This included even a nurse in your high school. It included a recruiting partner, and when you were in law school, a recruiting partner in a noted Washington, D.C. firm. You were confronted with some of these attitudes. Apart from any kind of legal context or case context, just as a general non-legal matter, what non-legal response, apart from simply success, can be made to those who reject affirmative action simply as unjustified preferential treatment?
Well, I'm going to change your question, okay? Because I don't feel I have to give a response. And I think people are entitled to their opinions, and I want people to think very carefully and deeply on this issue. In many states, votes are coming up on this question, and you as citizens will participate in that process. I think that the point as you think about it is we all aspire to a colorblind society. There's a pull in each of us that wants race not to matter. But the reality is that as much as we wish it away, it makes a difference in the society. Because the society is affected by it at every level. Whether it starts on in the economic situation, where many people of color are born in economically challenged circumstances, in school districts that are among the worst in the country, and who don't have an opportunity like others have to attend a Booker Washington high school, to where you go to summer camp or don't. So many of my lawyer friends, the people that they have as clients are people they met at summer camps. Many minorities never have the opportunity for that experience. To the extent that you understand that the structure of our society automatically makes race matter, then you have to know that to wish that it didn't exist, that the need for affirmative action wasn't there, is to be blind to a reality that's staring you in the face. As I said in my book, the right kind of affirmative action, the kind that the court has approved, is one where people have tried alternative methods and they failed, and where race is not the only criteria that people are admitted. They have to show basic qualifications and promise, but where you're giving them a chance to come to the beginning of the race. I came from the South Bronx, from a high school that has become, after I got there, and I was part of the reason it became a feeder to the Ivy League schools. But when I was there, there was only one classmate of mine who had gone to an Ivy school, and that was my Asian friend, Kenny. And he got into Princeton because he had a teacher who had just come to the school, who worked very hard to get him into Princeton. And he called me up and he said, "Sonia, come to Princeton. Come, you have to go to an Ivy League school." And what I said to him was, "What's an Ivy League school?" I'm a senior in high school. He explained it, explained how I went about applying, and I did, and I got in. I was a good student, but I wouldn't even have known to apply because I came from a world where that wasn't the expectation. And that's true of a lot of kids in a lot of communities. And without the kind of affirmative action that I was a part of, which was where it encouraged institutions to look more widely than they had previously, to identify people with promise, then I wouldn't have gotten to the start of the race. And I certainly wouldn't be where I am today. And so that impetus, that desire to be more diverse, more inclusive as a society, shouldn't end. It should be a part of what we pay attention to ensure that we're giving that promise of equal opportunity to every member of our society.
Thank you, Justice. We're on the subject of education, and we're here at a law school. And law schools, at least most of them, or many of them, are facing a lot of problems currently. Nationally shrinking enrollments, tuition issues, a very prolific media response that has been spreading, in many ways, skepticism about the value of legal education. What, again, for even our purposes here, what kind of creative, positive responses or roles in this context can law schools currently play?
You can tell we didn't rehearse the questions, okay? I think first, I talked to you about passion about the law. I think first that should be the role of law schools with their own students. There's a lot in practice that can disillusion you. Not everyone practices the profession in the way that one would want. But it doesn't mean that that has to continue. I think young lawyers can bring that new energy to environments to sort of put them back on track on what's important. Most law firms welcome pro bono work. And if you're a young lawyer really committed to the practice, you'd be doing it voluntarily, not because you're being forced to do it. I think law schools should be encouraging pro bono work from the beginning of first year. And I think some are, but some aren't. And I think that is part of the charge of a law school, to remind students that law is about service. Law is totally about helping people and institutions have better relationships. So everyone who comes to you as a lawyer either has a problem that they're asking you to resolve with an institution or with other people, and you have to find a way to protect their rights and to sort of refocus this trauma in their relationship. If you are a corporate lawyer, you're helping people in their business relationships, how to interact with their customers, with their employees, with their stockholders, with their administrative people in better ways. And so for me, law is just service. Are you caring about the people you represent? And so long as law schools deliver that message to law students, make them passionate about the law, make them the ambassadors to others. Remind them of all the wonderful things that law has done. For me, it's easy. I point to Brown versus Board of Education, because I wouldn't be here, as most of you wouldn't. All the women in this room would not likely be here. Certainly none of the minorities would, if it wasn't for Board versus Brown, because that's the one who told, that Supreme Court case told people that we could not be a segregated country. And I think almost everyone fundamentally accepts that as a working principle of our nation. But that was law that did that. It wasn't simply choice by people, and there was a lot of resistance to it. Law has helped people get minimum wage. Some people may not like it, but there's a lot of people who are helped about it. Lots of people complain about personal injury law. especially businesses. They spend a lot of time complaining. And maybe there should be some reform. But people forget that tort law arose because corporations were forgetting the value of human life. And they were producing products that were known to be dangerous to other people and putting them in commerce. They were doing things that were harming people without thinking about it. As with all things, nothing is perfect. No system of law and no part of society is perfect. And we can talk about reforms, but we shouldn't forget the fundamental value of being a lawyer. The society needs us. It needs us because we're imperfect human beings who are going to be troubled by each other. We don't live peacefully on our own. And we need lawyers to help us keep our relationships in a positive form instead of resorting to arms or to combat. It sounds hokey, but we organize, the law organizes relationships. And we as lawyers can help them. For me, law schools should have plenty of clinical programs where young lawyers are going out into the community and serving community members. Those small cases that young lawyers deal with give you a real sense of accomplishment because they help you see what you can do on a bigger scale when you get out into practice. I do think that every law school, and I know Dean Levitt has told me you already have it, should be putting more emphasis on ethics in law, because I think that's critical. And I'm so pleased to hear that TU Law School continues to have a professional responsibility program for all of the 3 years of students. So you're on the right track. But you need more clinical programs, by the way. Where's my clinical program teacher who I said I would? I told you I would get the message out. In short, but I think above all, the public has forgotten all the good we do. And I think it's important that we don't forget it. And that those students who come to law school be reminded of it constantly, so they go out and be our own ambassadors.
Thank you. We're reaching our conclusion, but I have one more substantive.
It went that fast?
It went pretty fast. I have one more substantive question, and then I have a little tail of our kite that I want to ask you right at the end. But
if you stick around, I'll come out at the end of this. Okay, I'll come around.
But speaking of creative solutions or creative responses that law schools can have to current issues facing law schools.
Oh, I forgot one thing, Bob, in answering that question. I think law schools are going to have to get together in regions and divide up specialties. I think that there's certain pride that every law school has in their own existence and their own identity. But clinical programs and teaching is getting so expensive in terms of maintaining a first-class faculty in every area of law, in doing clinical training in every area of need. I think law schools and universities generally are going to have to divide up specialties and let students visit each other's school, have consortiums like some of the sister schools have, and let students who have a particular interest, let's say in immigration law, go to the one school who has the best faculty in that area. I don't think that we can maintain the expense, law schools, of trying to be number one in every area. It's almost impossible to do.
Well, we have been, I think, taking very, very interesting strides here, which includes some work on the tuition issue, but also what we're doing, and the three chief proponents are in the room today, President Popham, Provost Blaze, and Dean Levitt, have been drawing us now closer to the undergraduate program and deploying resources that will include being able to participate broadly, eventually, and we've dipped our toe into it this year, in the undergraduate program. And the way we're envisioning this is as a liberal arts involvement that will not be strictly pre-professional. As such, although some students, may turn it into a pre-law kind of thing. But you've written, I think very interestingly, that when you were at Princeton, you at least later on came to believe or feel that you were blessed that Princeton at that time anyway did not have a pre-law program as such because it plunged you into a bigger pool of curriculum. Could you just comment a bit about why you feel that, or at least why you felt that college-bound students should avoid that kind of pre-law approach and maybe expose themselves to a wider range of learning?
I don't know how many of you know that many medical schools are now taking students who didn't major in the sciences, who took the fundamental prerequisites but went out and did a major in another area. One of the reasons they're doing that is because they're finding that these students who were holed up in libraries or science labs don't know how to interact with patients. And so they figured if they got students from different disciplines, they might make doctors who actually know how to talk to patients. My brother, who's a doctor and did a special program, science-based program, often tells me that he is sorry. He doesn't feel like a well-rounded person. And that he feels himself sort of catching up to learn new things now, later in his life, that he wished he had been introduced to when he was younger. The value of education is not what you do with it. It's not the profession that you study for. It's not the occupation that you do. Most learning in occupations that you're ultimately going to do comes from experience in that work. You have to learn some fundamentals, and in law school, that's what they're supposed to teach you. The same thing in medical school. But a liberal arts education is not there to teach you a profession. It's there to make you a more well-rounded, interesting person. If you become that, you'll be a great professional. Who are the people who are most successful, Bob, in law? They're the interesting people who can engage others in conversation about their work, about their lives. They're the leaders who bring to any enterprise excitement, some off-the-wall knowledge that stimulates people to think more broadly. That is because they've educated themselves more broadly and draw from different areas, different bits of information that they can then create something new from. Don't forget to love learning for the sake of learning. You might be able to use it later, but sometimes it's just that little tidbit of trivia that can give you a leg up in something you're doing, that can spice up a night with friends as you talk about the most absurd things but still have fun doing it. Become an interesting person. An interesting person is always a successful person because they know how to engage the world. And so that, for me, is the value of a liberal arts education and not going to a pre-law course. Lawyers have to practice law, but we're being asked to help people in every field of endeavor. We help scientists resolve their disputes about medical technology, about patents, about all sorts of scientific issues. We help businessmen with all of their endeavors. We are asked to look at any field that exists in the world, any occupation. We have to learn about it to help people resolve their problems. And so how are you going to do that if you haven't educated yourself on some of the basics of the world? When I went to college, I took a course in economics, in philosophy, in religion, in art, in economics, sociology, psychology. I did that variety of courses because I wanted to understand the basics of the major fields that engage the society today. No one should graduate from college today without a basic program in computers, because it's such a part of our society today. I haven't done it and I regret it, but I have studied computers since I was in college. I was one of the earlier people who did it in law, who worked with computers in law school. But my point is, the world is a very, very big world with lots and lots of theories. Understand the basics of all of them, and you will maneuver the world a lot better.
Well, now for my tail of the kite question. And I don't know who submitted this. I suspect it's either a high-flying Baltimore Orioles fan or a currently low-flying, cellar-dwelling Red Sox fan.
Okay.
I don't know which, but...
I think that we're going to beat the Red Sox this year.
But this questioner wants to know, are you willing to bet, and I would fictionally bet, or as a gentle justice bet, are you willing to bet on the Yankees for the AL East this year?
I answered this at Booker, Washington. And I told them the story that in 1978, the Yankees were like 9 or 10 games out of first place, and Boston was number 1 at the All-Star break. And I bet a bunch of friends at the law school that the Yankees would come out number 1. One of my friends, who's a real mathematician at the law school, still is, said to me that it was statistically impossible for the Yankees to win. So I said, bet you they will. And when did they win? They won when the season ended, a postseason one-game tiebreaker between the Yankees and the Boston Red Sox. And up to the plate, and I think it was the 7th inning, comes Bucky Dent, who was the then Yankee catcher. And this was the era when catchers were not power hitters. And Bucky had an anemic ERA. And what do you know? They throw him a pitch and he hits the winning home run. And I won the bet, okay? Taking a page from my friend, however, and doing the math in my head, I don't think I'm going to make a bet this year. And really, it's the schedule that makes me not say that it's really going to be really tough for us. Because we're playing a lot of teams that are not competing for the wild card. And that means for us to catch up, not only would we have to win nonstop the rest of the season, but they would have to lose to other teams nonstop. And I think that that's hard to do when you're talking about a multi-team competition. And so I'm having a hard time making the bet this year.
Well, it was statistically certain that this would be an enjoyable conversation. On behalf of all of us, the law school, TU, and everyone here, thank you so much, Justice Sotomayor, for this conversation.
It was so wonderful to see you again. Thank you, everybody. All right. Thank you.